everything that you wanted from this webinar. So now, without further ado, I wanted to give the microphone to Mickey to talk about the topic. Mickey, it's all yours.
Thanks, Ralph, and thanks for the nice introduction. Folks, I hope you can hear me because this is an important topic for you to hear about and for us to talk about. So why don't we start with what are we going to talk about today? Well, pay equity is here. Most of us know that. We've heard about it over the last couple of years. It's had an impact, hopefully, in some way in your organization. What I'm here to tell you today is momentum is growing, and it's growing fast, and it's having a real impact on you as the employer. In fact, if you have begun your pay equity journey, that's the way I like to think of this, some of you have not started your journey. I believe someone once said, the greatest journey of 1,000 miles starts with the first step. Some of you may not have started your pay equity journey, but for those of you who have, my job today is to bring you up to speed on cutting-edge developments and also increasingly best practices and strategies on how to continue and how to most effectively move forward on your pay equity journey. We'll talk about the rapidly changing landscape in the area of pay equity. We'll discuss safe harbors, which increasingly is something that you should be taking advantage of. Pay equity should become more a part of the fabric of your organization and your pay system, but let's take full advantage of the safe harbors that exist increasingly around pay equity. We'll put the pieces of the pay equity puzzle together, and then we're going to discuss briefly, I won't go into all statistical detail today, but we will discuss briefly how to conduct an effective, proactive pay analysis. And then finally, we'll wrap up with getting pay equity right. So with that in mind, where do we start? Well, let's start at the beginning. Why is pay equity such an increasing area of focus? It's the pay gap. We know this. Everyone on this webinar should know this by now. Women the last several years have made about 80 cents on the dollar as men. That's nationally. African American women actually make quite a bit less, 63 cents on the dollar, and Hispanic women make 54 cents, almost half as much as males. Not just white males, by the way, but as males on the throughout the country. What does that translate into practically for a Hispanic woman working in the American workforce today? Well, over the course of a 40-year career, she can expect to make at least $1 million less than a man. Let's think about that for career earnings, for retirement savings, for life. These are practical gaps. These pay gaps have been stubborn, they've been persistent. We've largely plateaued around these numbers for the last many years. And so, various interested parties have come together to address that pay gap. How we do so, and how we do so effectively, requires us to really understand what that pay gap is. And a good way to start is to define our terms. Often we hear people say there should be equal pay for equal work. That's actually not typically the case for most of my clients and their pay systems. Think of your pay system. Is it designed to pay equally for equal work? Well, Robin and I are in the same job. We're doing equal work, but he's been with the organization 12 years longer. His performance has been better the last many years, and he brought greater education and more prior related experience into the job. Yes, we're doing the same job, but when you take those greater attributes into account, if your pay system is designed to recognize and value tenure and performance and prior related experience and education, we would expect him to be making more than me. Our pay system is working right if he's making more than me, if it's based on legitimate factors that drive pay in our pay system. So truly the goal of equal pay for equal work is somewhat, as statisticians might say, somewhat misspecified. It's actually not our goal, nor should it be. Our goal should be pay equity, which is to pay our employees fairly, taking into account those legitimate drivers of pay. If our pay system is designed to recognize work experience and education, we should be paying some people more than others in the same work. But we ought to be able to explain those pay differences. If we can explain the pay differences we have based on legitimate factors in our pay system, we have achieved pay equity even if there are some pay gaps. If, on the other hand, after looking at our workforce and the legitimate drivers of pay, if we have unexplained pay differences, then we've not achieved pay equity. We're going to talk a little later about the goal of pay equity. One thing for you, those of you on the call who are beginning your pay equity journey, take these terms, share them within your organization. Contrast equal pay for equal work, which is generally not your pay system's design and goal, versus pay equity, which should be the pay system's design and goal. Now, in addition to what we might want to achieve, there are other external pressures coming to bear. We're not the only ones focused on pay equity. If you're a publicly traded organization, increasingly activist shareholders are putting great pressure on organizations to achieve not what we call pay equity, but rather pay parity. Pay parity stands for the proposition that our goal should be a zero pay gap across the entire workforce, similar to that 80 cents on the dollar across the entire U.S. that I mentioned a moment ago. Our activist shareholders often say, your pay system should net out paying women 100 cents on the dollar as men and minorities 100 cents on the dollar as white folks. I want you to think about this. Is our pay system designed to recognize perfect parity? No, it's not, but our shareholders, they don't want to be bothered with the complex details of our pay system design and administration. Rather, they want you to get to a bottom line of zero pay gap across the organization. We'll talk about how to address that expectation and demand. And finally, pay transparency. I would put this under the following phrase. There is an inexorable march to pay transparency. It is happening now. We're seeing changes day by day. I'll unpack some of those for you. The key here is, I grew up in a generation, I've been doing this for 25 years now, I grew up at a time where people just didn't talk about their pay. Whether it was company culture or societal culture, or whether there were practices or actual policies within the organization that discouraged or prohibited employees from speaking about pay, people just didn't talk about pay. Well, that's not the case anymore. Your employees, increasingly your millennial employees, they are perfectly comfortable speaking just as candidly about their pay, other people's pay. They ask you about it. They will ask the organization. There are many states and now several foreign countries that are moving and pushing employers in the direction of pay transparency. The concept is this. If you're not discriminating in your pay processes, then why do you feel you have anything to hide? Aside from old habits dying hard, where people just didn't talk about pay, why can't we and why shouldn't we, goes the logic behind pay transparency. And a final concept there, that'll segue into one of our next pieces, is pay transparency is deemed to be one of the great ways to attack that pay gap. We'll come back to that in a moment. But before we do that, let's define a few more terms. I want to talk about safe harbors. My firm is based in D.C. We do work on a national basis in the area of labor and employment law. I focus on pay equity nationally. I am based in Denver, Colorado. Well, my great state of Colorado just finalized, with the governor's signature, a new robust pay equity law. It is one of many, about 15 states over the last 2 years, a wave of state pay equity laws that are aggressive and that are challenging employers in ways they haven't before. But Colorado did something that Oregon did, Puerto Rico did, and Massachusetts, and we're seeing growing momentum. Think of this as the concept of the carrot and the stick. The stick is much more aggressive pay equity laws that place much greater demands on you as an employer. We'll talk about that in just a little bit. But the carrot, that's a safe harbor. A safe harbor, there are provisions in these new laws in many states that say if you conduct on a proactive basis a compliant pay equity analysis, do this before you get any claims against you under this new law. If you can demonstrate that you have sought to get your house in order pay equity-wise, not in response to claims of discrimination, but rather on a proactive basis, then you can invoke the safe harbor and say, yes, there may be claims of discrimination against us under this new law, but we're going to demonstrate that we've conducted proactive analyses, that they comply with the law, and that we should be insulated from liability. We should have no exposure at all in these claims if we have properly conducted proactive analysis. This creates a very big incentive for employers to conduct analyses on a proactive basis, certainly in the states that have these safe harbors, but you'll see over the course of this webinar, more generally, the argument in favor of proactive analyses keeps getting stronger. There is only one state so far that has a true deep safe harbor, meaning a complete insulation from liability, and that's in Massachusetts. Folks on the call, if you sit in Massachusetts or if your organization has substantial employees in Massachusetts, it is foolish of you, risk tolerance-wise, not to conduct proactive analyses. The benefit is so great under Massachusetts safe harbor law that you're just imperiling your organization unnecessarily if you're not conducting analyses. But in Colorado, Oregon, and Puerto Rico, and in other states, so we'll see growing momentum over the coming years, there's a more shallow safe harbor. It doesn't insulate you entirely from liability, but there are significant parts of liability that evaporate if you conduct proactive analyses in these states and territories. We'll come back to that a little bit more when we talk strategy and best practices. All right. It's important to understand the distinction between what we're seeing, the federal government versus the states. Interestingly, I do a lot of work in the area of OFCCP, for those of you who are government contractors, and EEOC, systemic pay discrimination claims. Those agencies continue to enforce pay equity very vigorously, in fact, maybe even more vigorously than in the previous administration. But for whatever reason, perception-wise, there has been a growing sense that in the Trump administration, there may not be the same vigorous enforcement of pay equity laws as we might see in the previous administration. That may or may not be true. It hasn't been my experience. OFCCP and EOC under this administration are vigorous and aggressive in the area of pay, but many states have specifically said we are going to pick up the pay equity torch. We don't necessarily trust that the federal government will protect the rights of employees and citizens, and so we individual states are going to pick up the torch. We're going to create new aggressive pay equity laws in our states. I mentioned Colorado most recently, just about 2 months ago. Very interesting, very aggressive state law. Colorado joins about 15 states over the last couple of years that have put new laws in place. And oh, by the way, we will likely see another several states finalize new aggressive pay equity laws before the end of this year. For those of you who are multi-state employers, this poses particular challenges for you. It's important that you understand the patchwork of these differing and contrasting laws in each of the states in which you operate. And even some big cities on their own have put in specific city laws, city ordinances with regard to pay equity. In addition, for those of you who are outside the U.S. as well, we have seen significant increase in pay equity laws there, whether it's new discrimination laws or reporting obligations. We'll talk about that in just a bit. The key to take away here is we do have a checkerboard, a patchwork of obligations across different jurisdictions. Get up to speed with that. I keep a chart and a survey of those differing laws, it's important that you do so as well. All right. We have this pay gap, and it's been a persistent plateaued pay gap for quite a while. What new tools are we seeing that are being used to attack the gap? This is very deliberate and coordinated. This is not haphazard that the different states are doing things, and that activist shareholders and that foreign countries and federal enforcement agencies are increasing their attack on the gap. Think of these as the new tools to attack the gap. While I mentioned the state and international and foreign country equal pay laws, OFCCP and EEOC deep dive investigations, but let's pause for a moment on what we call naming and shaming. This is another tool that says, this falls under pay transparency. Remember, we defined our terms at the outset. Naming and shaming, in essence, stands for the proposition that you, employer, if you've got nothing to hide, then don't hide it. So, for instance, in the United Kingdom, starting in 2018 and now annually, in April of each year, if you have 250 more employees in the United Kingdom, you must post in a prominent place on the homepage of your company's website. You must post the pay gap that exists between men and women in management, in professional, in lower level jobs. You must do so for base comp, and you must also do so for bonuses and some other elements of compensation. EEOC, for just about all of you here on this webinar, have 100 or more employees. You will, by September 30th of this year for the first time, do pay data and work hours reporting to the EEOC. France now requires that you do reporting, and it will kick in 2019 into 2020. You will be required to submit information, and you will get a pay equity rating. And if your rating is below a certain score, then you will be required to, in essence, make changes to your processes and also submit an explanation as to why your rating is below a certain point. Germany requires you to do pay transparency and, in a sense, naming and shaming as well, and that's effective now. We'll talk through that in a moment. What Germany has done is fascinating. But it's not just laws. It needs your activist shareholders. It's your millennial employees demanding pay parity and pay transparency. And we talked about all of those are the stick, if you will, and it's a big pay equity stick. We talked about the safe harbors that are the carrot. We'll talk about how to integrate the safe harbors in just a little bit. All right, let's break this down. I want to touch on each of those new tools to attack the gap and talk about the most recent innovations in those areas. I mentioned there are about 15 states since 2016. Think about how blindingly fast this has moved, folks. California was the first to put the new big, robust, aggressive pay equity laws in place. And that was ancient history, going back to 2016, only 3 years ago. We have seen many states now follow in their wake. California, by the way, not to be outdone by those who come after, each of the years since 2016 has expanded its pay equity law to put more burdens on employers. I'll tell you about the most recent aspect of that in a moment. But here's what I want you to understand in a big picture about these individual state laws. Number one, they are designed very intentionally to make it easier to bring and to win claims of pay discrimination. The truth is, most states have had pay equity laws on the books for decades. California had one since 1949, which was rarely used, and when it was used, when claims were brought, defendants, the employers, won almost all of the time in those claims. I won't explain the reasons for that, but the bottom line is those laws were remarkably ineffective in finding pay discrimination. The changes to these laws across 15 states, with another 10 to come or so this year, are designed to make it easier to bring and win pay discrimination claims. How does it do that? Well, number one, it significantly expands who can be compared with whom. Under traditional federal law, the concept is you can only compare employees who are similarly situated, that's the key phrase, similarly situated for pay comparison purposes. And that generally has been interpreted the last 50 years to mean people in the same job. But think about your organization. If we wanted to do a true systemic review of your pay system to determine its aggregate effect on people by race, by gender, by other categories, we would broaden those groupings to job family group, function, other larger constructs by grade, by career band, by salary band, by market reference point. We would want to use the constructs that exist in your pay system on a broader level to see where the trends emerge. When you slice down by job title, let's say you have 3,000 employees and you have 1,500 job titles in your HRIS system. Well, you're averaging 2 employees per job title. If we did a comparison at the job title level, you probably wouldn't find very much in the way of pay discrimination, but that's because you don't have very much to compare. The breakthrough that many of these states have said is compare people on a much broader basis. California started by saying substantially similar employees. You no longer need to be truly similar, just if you're substantially so. Massachusetts said comparable employees. You no longer have to be similar or equal. Your jobs just need to be comparable. They may be very different jobs, but are they comparable in terms of how you paid for them? Oregon said work of a comparable character. Washington State said, are you similarly employed, full-time versus part-time, and so forth. That's one big leap among these states. Another one, and this is a big deal, let's spend a moment on this, is most of these state laws say employers must be able to explain the entire wage differential when there's a claim of pay discrimination. I want you to think through that with me. Let's say you have 10 female and 10 males. They're all engineers doing similar jobs. You're comparing them. The men are making $10,000 more than the women. But when we control for tenure and performance and time in position and education and a prior related experience, we say, I have great news. $9,800 of the pay difference is explained by legitimate factors. We've explained 98% of the difference. Under traditional federal equal pay law, if you can explain 98%, you are no longer what's called statistically significant. The amount of difference is what we call in the law de minimis. It is minor. And you would win under traditional federal law. But these laws in the state are expressly designed, remember, they're there to make it easier to win these claims. The concept here is employer, you own the entire pay system and you own the entire pay difference. You ought to be able to explain that entire pay difference. If you can't, then there's discrimination. Now, here's the good news. If there's a $10,000 difference for those 10 female employees, if we explain 9,800 of it, well, we substantially reduce our liability. But watch this. I'll tell you this as a lawyer. I didn't write these laws, but I understand where it comes from. If the plaintiff bringing the claim against you, those 10 females, if they're able to demonstrate that you can't explain the entire wage differential, they win. Now, their damages are reduced by the amount that you can explain, but prevailing plaintiffs under these laws, they will get attorney's fees. So this lawsuit has gone on for 3 years, and you've worked hard to explain or defend those differences. And you've gotten down to a $200 difference, but you had to do a lot of work with me as your defense lawyer, with labor economists who did analyses, the depositions, the lawsuit itself. Plaintiffs rung up fees of $1.2 million for their plaintiffs' attorneys. In my example, under California, under New York's law, under New Jersey, Washington, Oregon, Massachusetts, under Colorado, my home state, the plaintiff would win if you can't explain that final 2% of the pay difference, and then the attorneys are entitled to their full attorney's fees. So again, easier to bring and win claims. We'll talk about how to counteract this in just a few minutes. In addition, and most of you have heard of this already, there's a growing wave of bans on asking for applicants' salary history. By the way, If you as an employer are asking your applicants for their salary history in the application process, stop. We'll talk about an easy pivot from there in a moment. But virtually all of these states and many of these big cities that have put in laws have prohibited you from doing so. Now, California, I mentioned, is thinking creatively each year about new aspects of pay transparency, pay equity. What California said most recently, this became effective January 1 of 2019. This falls under pay transparency. It requires that employers, upon request from their applicants, provide a pay scale for the position that they're being considered for. So I want to think about that. You can no longer ask for their pay history, but when you ask them, what would you like? What are you looking for pay-wise? They can say, well, before I can answer that, I would like to be able to know what the pay scale is. And that may be the min to max for that pay grade or the market reference point for that particular job. You can provide the actual min to max of employees who are in the job. There are different ways to do this. One key takeaway on this, by the way, is if you get this request for your California applicants, provide the information orally. There's nothing under the law that requires that you provide it in writing. If you give a min to max pay scale to an applicant, there's nothing that prohibits them from sharing that with your competitors, posting it online, putting it on Glassdoor, a website that all can go to, where employees and former employees and applicants give input on pay and working conditions. So let's be cautious about how we do it. But we will see other states follow where you will be required to tell the applicants what they may be paid before asking them how much they want. All right. Our states are putting in this patchwork, but they're not alone. For those of you who are global, the UK, I mentioned the pay gap reporting on the website. Germany, fascinating law, which says that for each job title in which you have 6 or more employees, any of those employees can ask for the actual pay of the other employees. I'm a female in a software engineer job in Stuttgart in Germany, and I am concerned that I may not be paid fairly. There are 20 people in my job. I asked the HR folks for the actual pay of the other 19 people. Under German law now, they are required to provide it. Not with the person's name or their race and gender or other identifying information, but the bottom line is that this is pay transparency, just another version of it, where employers have to pull back the curtain. France, as I mentioned, soon will have a pay rating and ranking system. Others, Iceland requires companies to prove the pay of their men and women is equal. And Sweden, just as another one of these tools to attack the gap, requires a survey of gender pay differences every 3 years. We have proposals in Ireland, in Canada, New Zealand. We have others as well. They're coming online very frequently. But there is huge momentum on an international basis. If you are conducting proactive pay analyses, as I recommend that you consider doing, more and more of my clients are doing so on a global basis, both within the U.S. separately and then also looking globally all in, and also in individual countries where they have substantial populations. All right, we mentioned this. I won't belabor it. One of the critical shifts legally is in attacking the gap is to ban asking for salary history. Why is that? We all understand this. If women are making 80 cents on the dollar as men, and you ask your female and male applicants for their previous salary, and you rely on it in some way in making starting salary decisions, well, if women are making 20 cents less than men, we're going to carry over, we'll perpetuate the pay gap that exists societally. We don't have legal responsibility for the previous employer and what they paid and why, but once the employee enters our workforce, what these laws say is you can no longer rely on that previous pay gap. Don't perpetuate it, don't carry it over and cement it in. Here are states on the left and cities that have banned salary history. You have others that are proposed on the right. This is very quickly growing. And the upshot, as I mentioned, is I would just, as a best practice, remove asking for salary history. Let's go back for a moment on that. That's important. Asking for salary history. An easy pivot is to replace the request for salary history with a request for salary expectations. Instead of you asking for history and then the employee, the burden's on us as the employer to figure out what to offer. By asking for salary expectations, we have a simple pivot to applicant, what do you want? Some states, by the way, had considered banning asking for salary expectations as well. New Jersey's proposed law a few years ago would have banned asking for salary expectations, but that law was changed in its final form. That governor actually vetoed it, and the current governor has signed a law very recently that does not include a ban on salary expectations. All right, those are legal pressures that we're feeling, but there's also pressure coming from within the house itself. Our activist investors, they're buying into the company with the sole purpose, some of them, of putting pay parity on our shareholder meeting agendas. They are coming to the CEOs of the company and saying, you must make an announcement about pay parity. And the CEOs in turn are coming to HR and in-house counsel and saying, this is going to get done. The pressure is coming from above. Now, I'll unpack this piece in just a moment, but if you're looking at what we call a pay parity analysis, contrast that with pay equity. Remember how we defined our terms. Pay equity is not getting to 0 cents on the dollar, and it's only comparing those people who really are doing similar or same jobs. Pay equity is designed to say, can we explain our pay differences? Pay parity says, are you at a zero gap difference? When your shareholders come and demand things of you, they're not asking for pay equity. They're not asking for explanations of your pay gap. They're demanding a zero pay gap, and they're demanding you publish the results. A few years ago, Silicon Valley, all the big tech employers came out with announcements. We're proud to announce that women make 100 cents on the dollar as men. They didn't do that simply because they were generous or somehow immediately interested in publicizing that. They did so under pressure from activist shareholders. The financial industry, late 2018 into early 2019, the world's 10 biggest banks came out with pay parity announcements, again under pressure from activist shareholders. The shareholders are moving industry by industry. Here's a very important point. If you're trying to address this issue of zero pay gap company-wide, conduct that as a separate project, a pay parity analysis, not a pay equity analysis. And I'll define those different analyses if you in a moment. But conduct these as two separate analyses. You'll see in a moment that one is designed to keep privilege and confidential. Another one is expressly designed to, in essence, publicize it. You don't want those to cross over. You don't want bleed between those two projects. Conduct a pay parity analysis separate entirely from your pay equity. All right. What are the pieces of the puzzle? Well, you have a puzzle here in front of you with the latest, biggest trends in pay equity. Starting from the top left, we have private class pay litigation growing. If you're a government contractor, very aggressive OFCCP investigations. International pay, I'm just going around like clockwise here. Equal pay versus pay equity, know those terms. Define them. Set expectations within the organization. Let's stop looking at salary history. Let's pivot to salary expectations. If you are a publicly traded company, anticipate that our shareholders are going to be making pay parity demands. We'll talk about in a moment how to respond to it. Know that your employees are increasingly aware of pay differences, the demands for pay transparency, and they're much more comfortable bringing complaints. And where are they going to bring those complaints? Well, increasingly under this patchwork of state equal pay laws, which make it much easier to bring and win pay claims. All of this when you go around the horn here, it comes back to the center, which is consider privileged proactive analyses to protect your organization. In the states with the safe harbors that I mentioned, there's a particular compelling reason to do so, but even outside of that, for the states without safe harbors, but that require that you explain the entire wage differential, proactive analyses are a very effective tool to minimize your exposure. I'll show how in just a moment. So where are we today at this moment in our collective pay equity journey? More than ever, employers face increasing pressure to ensure fair pay. Many of you are conducting proactive analyses. I encourage you to do that, but I do a lot of these, and sometimes I review those that were already done. Many of you are doing them wrong. The question at this moment in time where we are committed to pay equity and we're feeling pressures around pay equity externally from employees and shareholders and from the law, how do we get pay equity right? Well, I mentioned this a moment ago, but I want to drill down a little further because often I find that we're just not doing this as strategically as we could. Sometimes we're doing it flat wrong. I just did a webinar for the compensation committee of a large company yesterday where they had done a pay equity analysis and then were planning to announce to the world the results of that analysis. Their employee resource groups, their women's group, their minority groups, their disability groups, they're all clamoring for employers to release the results of their pay equity analyses. Don't do it. Now you have to respond to the increasing pressure for pay transparency. What is the strategy here? Well, let's conduct a pay equity analysis first. Do that under privilege. Have your attorney involved. We'll talk about how to do that effectively in a moment. And maintain confidentiality. At no point are we going to divulge the results of our pay equity analysis, what the groupings were, where did we find unexplained disparities, what adjustments did we make. We'll talk about adjustments in a moment. Once you have completed your pay equity analysis to look at who really is paid differently within similar jobs and whether we can explain those differences, and then make adjustments where you need to. By the way, I do this all the time. Most of the analyses we do show that most of your pay gaps are explained by legitimate factors like performance and tenure and time and position and so forth. But sometimes we'll have differences we can't explain, and that's where we're going to make pay adjustments. But keep that privilege. I want you to think of this in sequence. Conduct your pay equity analysis first, find out where your unexplained gaps are, fix those unexplained gaps. And then after that, you're done with that project, put the top on that box. It's a black box of privilege. Now put that to the side. And let's next conduct what we call a pay parity analysis. I'm doing a bunch of these now where it is really a shareholder-driven or employee-driven reason to conduct the analysis with the express goal of making public announcements. Wholly separate from your pay equity analysis that's now sitting in the black privilege box over there, you're now going to conduct an analysis company-wide comparing everyone against each other to determine whether there is a zero pay gap for the workforce as a whole. And there are different ways to conduct these analyses. But the critical piece is do not flow your pay equity analysis and results into the pay parity project. Keep those completely separate because you are going to likely use your pay parity results to make public announcements. All right. How do we conduct, and I'm going to do this very high level today, maybe we'll do a webinar another time on the details of how to construct the analysis, but at a high level, how do you conduct an effective pay equity analysis? You want to take advantage of the safe harbors. You want to be able to insulate yourself or minimize liability with the coming wave of claims under state pay laws that are designed to make it easier to bring and win those claims. How do we conduct an effective analysis? Well, there's no magic to this, folks. Many of us are fumbling around trying to figure it out. Some of you work with non-attorney consultants, and by the way, there are many good non-attorney consultants out there, but the non-attorney consultants aren't thinking about this from a privilege perspective. They're not thinking about it in terms of not just the nuts and bolts of the analysis, and instead thinking about the broader strategy. Step one is we have to establish privilege. Do that first. Have your attorney involved. We'll talk about the ways you can do that in one moment. Once you've established privilege and now can maintain confidential work on this project, deciding on groupings for the analysis is key. Are you doing this in Massachusetts? Well, the standard there is comparing people who are doing comparable work. Are you doing this in California? The standard there is substantially similar. Are you doing this under federal, similarly situated standard? Are you doing this nationwide? And let's think about how we meld together. Let's blend together the different obligations to come up with a standard for grouping that is going to withstand legal scrutiny. Once you've done that, let's gather data. Many of you are concerned that you don't have the data you need. For example, raise your hands, folks. You don't literally have to do that, but most of us, our pay systems are designed to give credit for prior related experience. But do you have a field for prior related experience, years of experience in your HRIS system? Most of you don't. There are actually creative ways to use data in your system to get at career experience. We'll talk about that maybe on another webinar where we dig more into the detail. But my concern for some of you is you're not conducting analyses because of what we call analysis paralysis. If you don't think you have complete and accurate data in order to conduct a full analysis and get it over the finish line, you just may not do it at all. I'm going to show you in a moment how you do this in a way that takes data limitations into account. Gather your data, you've got your groupings, and now compare pay. You can do it at a base comp only. You can look at total comp. You can look at bonus, setting aside bonus on its own. I often do different components of pay. I will also sometimes do, under privilege, one base comp cut and one total cash comp cut to see if, well, yeah, we have base comp differences, but those may be made up for by variable or incentive compensation. The key is think about your pay system and let's design a proactive privileged analysis that mirrors the reality of your pay system design and administration. We're not trying to use a one-size-fits-all analytical model. We're trying to really get at what your pay system is designed to do and then how it's actually administered. Gather your data, conduct your analyses, and investigate your disparities. Most of the time you should find, ultimately, that your disparities are explained by legitimate factors, those tenure, performance, time and position, education. But in those areas where you don't, where you have been unable to explain pay differences, let's make equity adjustments there. And let's do it under privilege. I'll show you in a moment how to fold it into your normal compensation cycle so it narrows and eliminates your unexplained pay differences over time without putting it on the radar screen of your employees, your former employees, the EEOC, your shareholders. Let's spend a moment on the issue of privilege, because oftentimes we think, well, if I get my in-house counsel involved, then it's privileged. And your in-house counsel, by the way, may think that as well. Some of you may be on the call, folks. Come along and let's chat for a moment about that, because when you make an argument of privilege, and why is this important? EEOC, OFCCP, plaintiffs' counsel, increasingly in any claims against you, they will ask you, did you conduct a proactive analysis? And if you have not privileged it properly, you're going to have to turn it over. If you have to turn it over to EEOC or private plaintiffs' counsel in California under their new law, it's going to show them what the before picture was, where your unexplained pay gaps were. They may demand back pay. Maybe in your analysis, you've identified flags that you can't explain, and my recommendation to you, I do this all the time, is let's make current equity adjustments now and to affect us going forward. I generally don't recommend that you provide back pay for a variety of reasons. But if you get a claim and they demand your proactive analysis, and they see that you identified that there were pay differences that may have existed now for 3 years, well, under a statute of limitations, the plaintiff can demand back pay, not just salary adjustments, but back pay. So the key is we want to have our cake and eat it too. We'd like to conduct proactive analyses, but we want to ensure that they remain privileged and confidential, that we don't have to push them across the table to third parties that seek to do harm to our organization. And if you do not have your attorney involved, flatly, there is no privilege, and you're in danger of having to turn it over and it be used against you. If you get in-house counsel involved on the surface, meaning they just give you an initial letter or email saying, this is under my direction, please go and work with this consultant, go do your analysis, and do whatever you need to address it. That's in-house counsel on the surface. It's better than nothing at all. Any attorney involvement is better than no attorney involvement, but it's not a strong argument. If you get in-house counsel involved on the substance, they're actually involved in how do we group the employees? What factors will we control for in the analysis? What are the results? Do we think we have legal basis for saying we can defend this or not? Having in-house counsel involved there is good, but here's a challenge for in-house counsel. I literally read a new case on this just this morning. In-house counsel, if they're good, is giving you both legal advice and business advice. Good counsel inside should be your business partner. The problem is business advice is not privileged. It's only legal advice that is. And if your in-house counsel's advice is bound up, legal advice and business advice, then courts often say, well, it's inextricably intertwined, your business and legal advice, and so we are not going to recognize that as legal advice, legal counsel, and therefore it's not privileged. Having outside counsel involved in some way, even on the surface, lets you make a better argument for privilege, because if outside counsel is involved, they're not giving you business advice. They're not telling you, well, what is your budget and how does this fit into your broader comp scheme? They're giving you legal advice. And most powerfully, if you have outside counsel involved in the substance, you can argue strongly that your outside counsel was involved in the work in order to provide you with legal advice. So think about, just be deliberate. Let's be thoughtful at the outset, how we want to get our attorney involved and at what level. And that will tell us where our risk tolerance is with respect to privilege. Okay. What you have in front of you is a funnel. I do recommend that you conduct proactive analyses. And this is the funnel approach. Let's say you have 10,000 employees, but you're worried that you don't have prior related experience and education in your system. You know those affect pay, but you don't think you have what you need. Don't let analysis paralysis set in. Instead, use a funnel approach. And the funnel approach says take your 10,000 employees, group them as you think appropriate, and then pour them into the wide brim of the funnel. Include in the analysis only those factors that are readily available from your system. We all have date of hire. Many of us have date and position. We have performance. We have other factors that impact pay. By the way, I mentioned that we don't have prior related experience, but we have date of birth for benefits reasons, among others. You can use age as a very powerful proxy for career experience and include that in an analysis. All of those are readily available factors. And now suddenly you're going to explain away most of the pay difference you have. Step 3, notice that it's a much more narrow end of the funnel. Now instead of having to think about 10,000 employees, you may be thinking about 265 in total. And now to go back and just look at that much smaller group for purposes of reviewing data and personnel docs where there's additional information, such as prior experience and education and gaps in employment previously, or other unique aspects of the employee's attributes that may explain why they're being paid differently, that's something you could do at the very narrow end of the funnel. I do pay equity projects all the time where we allot maybe 10 hours to this very narrow end where we're reviewing data and personnel docs outside of the HRIS system, and that generally gets all the work done. Think about it, devoting one professional employee and one admin employee's time for one day to look at data and personnel docs, and then this is all done this step. And then what you're left with is the very narrow end of the funnel where you will be left with a few or perhaps even no unexplained disparities. It's only where you have those disparities where you want to think about adjustments. And now let's wrap up with thinking about practically our pay adjustments. If you've exhausted your ability to explain pay differences, you should consider pay adjustments. But how do we do it in a sophisticated way? Well, first, don't make lump sum adjustments. Don't make off-cycle adjustments. I don't recommend generally that you provide back pay. Instead, make your adjustments in the normal pay cycle. If, let's say, you begin your focal process on December 1, and on February 1 you actually tell employees about their adjustments, let's conduct this analysis in the quarter preceding your focal point. And then we can come up with where we need pay adjustments, and then we can make those adjustments so that they hit in our normal pay cycle, so that, for instance, Mary is going to get a 2.8% merit increase. We've now slated her for a 0.3% equity adjustment as well. So instead, Mary's going to get a 3.1% increase. So we're not going to tell her, here's your 2.8 for merit and your 0.3 for equity. Instead, we're going to say, here's your 3.1% annual increase. Good job. Keep up the good work. Make sure that we do this in a way that we can simply fold it in to our normal pay cycle. And if you do this right and conduct the analysis in the quarter preceding the beginning of focal, you will literally know exactly. We've decided to make $81,000 in equity adjustments for, let's just put a number on it, 35 females. You can literally take an equity reserve off of your payroll adjustment budget and then give out the payroll adjustment budget to the managers, who are then going to determine merit adjustments, and you will layer on top of that the equity reserve adjustments that you already have held back even before giving this to managers. Folks, this isn't rocket science. It's not something that's easily not explainable. The upshot of this all is that there's a compelling reason for us to consider doing proactive analyses. Many of you have made the commitment to doing so now versus 3 years ago. Let's make sure we get this right. Let's make sure we get pay equity right. And if we do it and then do pay parity analyses afterwards, they will very often demonstrate that you're at a zero pay gap. Go make your announcements based on the parity analysis, which is an entirely separate project, while still keeping your pay equity in the black box of privilege. And with that, that is pay equity today. Those are our biggest, most cutting-edge issues and challenges to think about. And if you have questions, you can let me know either through the chat function, and we'll follow up. I know we're just about at the end of our time, but we'll follow up, or you can send them to Rothan, and I'd be happy to answer them. And Rothan, with that, I'll turn it back to you.
Sure. Yeah, thank you so much. Great presentation. I hope all of our attendees were able to, get some real practical advice. We don't have a lot of time for Q&A, so as Mickey mentioned, we'll have the contact information in the slide. You can send the questions to us. We will definitely respond. We'll have a copy of the presentation, sent to you. We'll also have a recording of this. So we'll be in touch, and we just have one step. I think it's in a pre-approval stage by HRCI for credit. I will definitely keep you posted when we get that. And I think this is a conversation, as Mickey said. He has done webinars before with JOBfindah, and he will do more. And I will have a survey question so where you can give us some ideas about any follow-up topics. I think we'll wrap it up there. Thank you, Mickey, for a wonderful presentation, and thank you everyone for taking an hour of your time to attend this, and we will be in touch, and that concludes our webinar today. Thank you.